Good afternoon. My name is Sonia West, and I'm an associate professor of law right here at the University of Georgia School of Law, and it is my immense pleasure to welcome you today to the keynote address of the Georgia Law Review's annual symposium. We have already had a wonderful morning of terrific panels by some of the country's top scholars who have traveled here to Athens today to be with us. I look forward to more conversations this afternoon. But the highlight of our event, without doubt, is the presence of our honored guest, United States Supreme Court Justice John Paul Stevens. I must start my introduction of Justice Stevens with a confession. I am biased. I am very, very biased. I am one of the incredibly lucky people who have had the great life fortune of being chosen to serve as one of Justice Stevens' law clerks almost 15 years ago. 15 years, Justice Stevens, can you believe that? And I can say with complete confidence that my experience that year working alongside Justice Stevens has made me a better lawyer, a better teacher, and a better human being. And so objectivity is off the table. But the fascinating and impressive life experiences of Justice Stevens are really too numerous to recap in the time of an introduction, but I'm going to try to nonetheless touch on some of the highlights. Born in 1920, Justice Stevens is a native Chicagoan. And as a young boy, little John Stevens roamed the halls and the lobbies of his family's hotel in downtown Chicago, the Stevens Hotel. And here he crossed paths with such historical figures as Amelia Earhart and Charles Lindbergh. He lived through the Jazz Age, the Depression, the beginning and the end of Prohibition. During the 1932 World Series, when Babe Ruth famously pointed to center field and then hit a home run right where he had called it, then 12-year-old John Stevens was in the stands with his father. Lifelong Cubs fans, however, they were probably not cheering that run. A handwritten scorecard from the game still hangs in his chambers. And more than 70 years later, at the age of 85, Justice Stevens threw out the first pitch at Wrigley Field, and yes, he got it over the plate. Always a stellar student, Justice Stevens was graduated Phi Beta Kappa from the University of Chicago in 1941 with a degree in English. And only the call of duty would coax him to leave his home in Chicago, and that call came in World War II. He enlisted in the U.S. Navy on December 6th, 1941, and later earned a Bronze Star for his contributions to the war effort as a cryptographer. After the war, Justice Stevens returned to Chicago and graduated from Northwestern Law School with the highest GPA in the history of the school at that time. His academic excellence at law school led to a clerkship with Supreme Court Justice Wiley Rutledge and made Justice Stevens one of only 6 Supreme Court justices to have themselves once served as a Supreme Court law clerk. After his clerkship, he returned to Chicago and built one of the premier antitrust law practices in the city, while also finding time to work on congressional antitrust inquiries on Capitol Hill and teach classes at Northwestern Law and University of Chicago law schools. But it was his role leading a special commission to investigate the corruption allegations against members of the Illinois Supreme Court, which eventually led to the resignation of 2 Illinois Supreme Court justices, that brought new attention to this unimposing Chicago lawyer. He received accolades for his work, and President Richard Nixon appointed him to the 7th Circuit Court of Appeals in 1970. A mere 5 years later, then Judge Stevens received another call to duty, this time from President Gerald Ford, who nominated him to the United States Supreme Court. The Senate confirmed him in a vote of 98-0. Decades later, President Ford wrote in a letter, quote, "I am prepared to allow history's judgment of my term in office to rest, if necessary exclusively, on my nomination 30 years ago of Justice John Paul Stevens to the U.S. Supreme Court." Justice Stevens' service on the court speaks for itself. After almost 35 years on the bench, he became the 3rd longest-serving member of the court, and at 90 years old, the 2nd oldest at the time of retirement, although to some of us continue to maintain he stepped down far too soon. On the court, he continued to gain a reputation as a, quote, judge's judge, with a litigator's focus on the factual wrinkles that any case might present. He was seen at times as a maverick. He was frequently a lone dissenter. His devotion to ideals earned him the respect of his colleagues, even when they didn't share his views. In a recent interview, Justice Scalia was asked which justice was his favorite sparring partner, and he said, Justice Stevens, explaining, quote, "I think you should give the dissenter the respect to respond to the points that he makes, and so did John Stevens. So he and I used to go back and forth almost endlessly." And I can confirm that almost endlessly part that they did. Justice Stevens was also known for being the only justice to write his own first draft of opinions, and he would never relinquish them to his clerks until he was confident he had mastered the arguments and the factual record. He would then pass his draft along to his law clerks with instructions along the lines of, "Don't let me look like an idiot." For decades, he was also the only justice to rely on his own clerk's recommendations about which cases the court should hear, rather than pooling his clerks to review the petitions as all the other justices did. Another one of his former clerks has observed that, quote, "I can imagine few bosses so interested in the views of their employees, so prepared to engage in free-flowing debate, and so enthusiastic to be proven wrong." I can second that as well. We were mere 20-somethings fresh out of law school, yet he always treated us so humbly, and I assure you, quite wrongly, as his intellectual peers. But don't let those good Midwestern manners fool you. Justice Stevens is also very competitive, whether it's at the bridge table or on the golf course or on the bench. Once during my clerkship, Justice Stevens, a regular tennis player, came into chambers after one of his games, sporting a real shiner of a black eye. And apparently he had been racing so vigorously to return a ball, he crashed into the fence. When we asked him what on earth we should tell the other clerks when they were going to be asking about his black eye, he told us very quickly, of course, we should tell them to see the other guy. It was his well-known trademark to interject himself into the rough and tumble back and forth of oral argument by politely inquiring, "May I ask a question?" and often apologizing for taking up counsel's time. Yet frequent court advocates will assure you that what followed was always the toughest and most probing question of the day. Paul Clement, Solicitor General under President George W. Bush and a frequent court advocate, said that it was always Justice Stevens' questions that put you, quote, on your guard, because he's probably found the one issue that puts your case on the line. At the conclusion of a term working in the Stevens chambers, Justice Stevens presents all of his outgoing clerks with an autographed photo that we all treasure. He signs the photographs with the same inscription that Justice Rutledge wrote on the photo he gave to his law clerk, John Stevens. The inscription reads, "To my friend and former clerk, with appreciation and affection." So today, it is my honor to introduce to you, with great appreciation and affection, my friend and former boss, Justice John Paul Stevens.
Thank you, Sonia. That's worth the price of admission, I might say. That's an awfully nice introduction. I should say I'm not only proud of the fact that Sonia was willing to work for me for a year and it helped me immensely with my work, but I'm also proud of the fact that I have 4 more former law clerks who made two of whom made the trip from Atlanta to come over here, or 3 of them. The 3 came from Atlanta, and it makes me feel good to see my old friends and who still think it's not a waste of time to listen to what I have to say. So. In fact, I should probably apologize to the audience, because when I wrote out my remarks, I overlooked the theme of the sessions this week, which I've enjoyed very much, but I'm not going to tell you anything about New York Times against Sullivan. The topic of my talk is originalism and history. The notion that a jurisprudence of original intent will constrain the discretion of judges who seek to impose their own policy preferences on the law, has often been attributed to a speech delivered by Edwin Meese, then Attorney General of the United States, to an American Bar Association audience on July 9, 1985. In that speech, the Attorney General was particularly critical of Supreme Court opinions relying on the Due Process Clause of the 14th Amendment as a basis for requiring the states to adhere to specific provisions of the Bill of Rights. Quote, "Nowhere else," he said, "has the principle of federalism been dealt so politically violent and constitutionally suspect a blow as by the theory of incorporation." He then endorsed the then Justice Rehnquist's dissenting statement in Wallace against Jaffrey that, quote, "It is impossible to build sound constitutional doctrine upon a mistaken understanding of constitutional history." It was after criticizing what he regarded as the court's misuse of history that Meese announced that it would be the policy of the Reagan administration to press for a jurisprudence of original intention. Quote, "Those who framed the Constitution chose their words carefully. They debated at great length the most minute points. The language they chose meant something. It is incumbent upon the court to determine what that meaning was. This is not a shockingly new theory, nor is it arcane or archaic." Presumably, General Meese's criticism of the doctrine of incorporation would apply to Justice Alito's recent decision to rely on substantive due process rather than the Privileges or Immunities Clause as a basis for holding that the Second Amendment limits the power of the city of Chicago to control the sale and use of handguns. Meese's comments on original intent are somewhat ambiguous. As I read his speech, he seemed to place more emphasis on the motivation of the lawmakers than on the community's understanding of recently enacted law. At least I think that is how the legal community so interpreted his speech when it was delivered. Over the years, however, I believe scholars advocating adherence to a jurisprudence of original intent have given more attention to the understanding of readers of newly enacted legal text than to the motivation of the authors of that text. As an example of that approach, in his opinion for the 5 justices in the majority in the Heller case, which, as you know, held the Second Amendment protects the right to keep a handgun at home for purposes of self-defense, Justice Scalia devoted over 14 pages to a discussion of what scholars and others had to say about the Second Amendment during the decades after it was adopted. On the other hand, my dissent gave greater emphasis to a comparison of the text that James Madison had drafted with the proposals that he had rejected. I thought, and still think, that the text merely responded to the state's narrow concern about possible federal disarmament of state militias, rather than to a broader interest in protecting an unmentioned individual interest in using guns for purposes of self-defense. In other words, I applied what I think of as the original version of the jurisprudence of original intent rather than the more modern version. I sometimes wonder if my understanding of the correct reading of the Second Amendment's brief constitutional text would have had a better chance of prevailing if the original version of the original intent had been endorsed by the original version of the doctrine of original intent had been endorsed by the justices in the majority. Today, I do not plan to re-argue the merits of the court's rejection of the interpretation of the Second Amendment that had prevailed in the federal judiciary for decades, both before and after the court's unanimous decision in United States against Miller. Instead, I shall identify some of the problems associated with the use of history when interpreting legal text and explain why a particularly lucid comment by Justice Scalia in a statutory construction case may well provide more guidance to judges confronting novel constitutional issues than the so-called jurisprudence of original intent. My conclusions are twofold. First, history is at best an inexact field of study, particularly when employed by judges. Second, the doctrine of original intent may identify a floor that includes some of the rule's coverage, but is never a sufficient basis for defining the ceiling. I shall begin with a personal memory of an event that occurred in December of 1939 when I was a junior in college at the University of Chicago. Spill all over myself here. During the Christmas break, my parents, one of my brothers and I drove from Chicago to Florida to visit my oldest brother, Ernie, who then lived in Fort Myers. On our way, we stopped for the night in Atlanta, where the recently released movie version of Margaret Mitchell's best-selling book, Gone with the Wind, was playing. My dad was able to get us 4 seats in the balcony. I have a vivid but apparently somewhat inaccurate memory of a scene showing the devastation of Atlanta inflicted by Union troops under the command of General Sherman. As I remember the scene, when a solitary wounded soldier appeared and background music played the song Dixie, the emotional reaction in the theater audience was so intense that I was afraid even to whisper a comment lest my accent reveal the fact that Yankees were in the audience. It's a very vivid memory. While research by my present law clerk, Aaron Zielinski, has convinced me that my memory of the scene in the movie is somewhat muddied, I am sure that my appraisal of the emotional reaction of the audience was accurate. The audience was deeply moved by the portrayal of what for them was a tragic episode in their defeat in the War of Northern Aggression. That incident is relevant for 2 quite different reasons. First, the flaws in my recollection demonstrate that even eyewitness testimony about historic events may be inaccurate. Despite the clarity of my recollection of the intensity of the emotion that pervaded the theater, I am uncertain about the exact scene that produced that effect. Second, the reaction of the theater audience convinced me that their appraisal of the actual event portrayed in the movie might be distorted by the depth of their emotions. Margaret Mitchell's understandable bias in favor of the defeated participants in the Civil War may also have colored her understanding of events that provided the background for her story, and in turn influenced the thinking of millions of readers less familiar with the history of the period than she was. One of the themes of her story, indeed a theme that has colored the country's appraisal of events in the defeated states during the decade after the Civil War, is a belief that Republican candidates who won popular elections during Reconstruction were incompetent and corrupt. For example, she has no kind words for Rufus Bullock, the Republican governor of Georgia during the first 4 years of Reconstruction. As she wrote, quote, "A week before Scarlett and Rhett announced their engagement, an election for governor had been held. The Southern Democrats had General John B. Gordon, one of Georgia's best-loved and most honored citizens, as their candidate. Opposing him was a Republican named Bullock. The election had lasted 3 days instead of 1. Trainloads of Negroes had been rushed from town to town, voting at every precinct along the way. Of course, Bullock had won." And here is her description of Governor Bullock's administration during Reconstruction. Quote, "But far and above their anger at the waste and mismanagement and graft was the resentment of the people at the bad light in which the government represented them in the North. When Georgia howled against corruption, the governor hastily went north, appeared before Congress and told of white outrages against Negroes, of Georgia's preparation for another rebellion, and the need for stern military rule in the state." Finally, Mitchell describes the end of Bullock's administration. That October, Governor Bullock resigned his office and fled from Georgia. Misuse of public funds, waste, and corruption had reached such proportions during his administration that the edifice was toppling of its own weight. Even his own party was split. So great had public indignation become. The Democrats had a majority in the legislature now, and that meant just one thing. Knowing that he was going to be investigated and fearing impeachment, Bullock did not wait. He hastily and secretly decamped, arranging that his resignation would not become public until he was safely in the North. The historical discussion in the novel does not tell us what happened to Governor Bullock after he resigned. This excerpt from a more recent history of Georgia describes those subsequent events. In 1876, Bullock returned to Georgia and stood trial on various charges of corruption, conspiracy to defraud the state, and malfeasance. After the prosecution failed to substantiate its case and 2 Atlanta juries declared him not guilty, Bullock remained in Atlanta and became one of the city's most prominent citizens. He was president of Atlanta's first cotton mill, president of the English American Loan Company, senior warden of St. Philip's Episcopal Church, president of the Atlanta Chamber of Commerce, president of the city's commercial club, vice president of the Capital City Club, and a member of the high society Piedmont Driving Club. His significant role in organizing the Atlanta Exposition in 1895 included persuading Booker T. Washington to give a keynote address and acting as master of ceremonies for the opening day speeches. Another history of Georgia, sheds light on the source of Bullock's unpopularity during Reconstruction. Quote, after the war, Bullock entered politics as a Republican, which earned him many enemies among former Confederates and KKK members. On the strength of the black vote, he beat Confederate General John B. Gordon for governor in 1868. He used his northern business connections to attract investment, building railroads, schools, and industry. His support for black political rights, one man, one vote, made him the most hated man in Georgia among whites. Democratic charges of corruption finally ended his government. He fled the state but returned, was acquitted of all charges, and became one of Atlanta's most prominent post-war citizens, unquote. It is also relevant to note that John B. Gordon, Bullock's unsuccessful Democratic opposing candidate in 1866, who is described by Margaret Mitchell as, quote, one of Georgia's best loved and most honored citizens, unquote, has been tentatively identified as the leader of the Ku Klux Klan in Georgia during the years after the Civil War. The fact that the Klan's activities were shrouded in so much secrecy has not only prevented historians from positively confirming that identification, but also explains why ambiguity characterizes so many important historical events. The lack of knowledge about the activities of the Ku Klux Klan persisted for many years after the retirement of John B. Gordon. Indeed, in 1982, Elbert Tuttle, one of our great judges, recalled that when he had moved to Atlanta and began practicing law in the early 1920s, quote, in order to successfully try a case before a jury in Fulton County, it was necessary to associate a lawyer who had some close connection with, if not a member of, the Ku Klux Klan, unquote. From that comment, it is reasonable to infer that the Klan not only had influence on election outcomes, but also on the administration of justice. Perhaps the most important of the misunderstood historic events was the contest between the New York Democrat Samuel Tilden and the Ohio Republican Rutherford B. Hayes in the presidential election of 1876. Two well-respected students of history, William H. Rehnquist and C. Van Woodward, have written books about the settlement of the dispute over the outcome of that election. Quotation of just one paragraph from each of those books will show that even the most qualified historians may interpret important events quite differently. Tilden won a majority of the popular vote, but he may not have been the favored candidate of a majority of the eligible voters. In his book, quote, Centennial Crisis, unquote, Bill Rehnquist quotes this dispatch written by a U.S. Marshal in Mississippi on the eve of the election. Quote, I am in possession of facts which warrant me in saying that the election in the northern half of this state, that's Mississippi, will be a farce. Colored and white Republicans will not be allowed to vote in many of the counties. The Tilden clubs are armed with Winchester rifles and shotguns and declare that they will carry the election at all hazards. In several counties of my district, leading white and colored Republicans are now refugees asking for protection. A reign of terror, such as I have never before witnessed, exists in many large Republican counties to such an extent that Republicans are unable to cope with it. If it were not for rifles and shotguns, this state would give Hayes and Wheeler from 20,000 to 30,000 majority. That example in the Rehnquist book identifies the very real possibility that events like the Colfax massacre in Louisiana had indeed created a reign of terror in the South. Woodward's book, in contrast, does not even mention that possibility. There is no discussion of violent behavior by white supremacists that might have deterred voting by former slaves in Mississippi. Indeed, Woodward uncritically reports that, quote, the southern states were expected by all save the more hopeful Republicans to line solidly up behind Tilden. All except three of them, Florida, South Carolina, and Louisiana, were reported to have piled up safe Democratic majorities, quote, unquote. And that, quote, in popular votes, Tilden, according to official returns later, led his opponent by more than 250,000, unquote. There are similar gaps in our knowledge about the real decision-making process in other parts of the country. For example, the records of how New York City and Kansas City were governed when Tammany Hall and the Prendergast machines were in control are undoubtedly incomplete. When areas of uncertainty applied to the work of the most distinguished and best qualified historians, lawyers and judges who are not specially trained in that field must exercise caution whenever they are asked to apply a so-called jurisprudence of original intent to the process of interpreting the Constitution. Indeed, I think that was the Attorney General's real message when he made this concluding remark on the jurisprudence of original intent. Quote, this is not a shockingly new theory, nor is it arcane or archaic, unquote. Turn it to my second point. In 1989, the Supreme Court reversed a judgment of the United States Court of Appeals for the Fifth Circuit, holding that a male employee had no cause of action under Title VII of the Civil Rights Act of 1964 for sexual harassment by male co-workers. In his opinion for a unanimous court, Justice Scalia wrote, as some courts have observed, male-on-male sexual harassment in the workplace was assuredly not the principal evil Congress was concerned with when it enacted Title VII. But statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils, and it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. The case is Oncale against Sundown Offshore Services. In my judgment, that perceptive comment applies to constitutional provisions and not just to statutes. A study of the original intent of legal draftsmen or the original understanding of the relevant community will identify the principal reason that gave rise to a new rule. But countless rules go well beyond the specific evil that was the proximate cause of their enactment. It is for that reason that a jurisprudence of original intent, though always relevant and important, can play only a limited role in the court's adjudication of constitutional issues. Two especially important constitutional rules, the Establishment Clause of the First Amendment and the Equal Protection Clause of the 14th Amendment, dramatically illustrate the point. The former was discussed at length by then Justice Rehnquist in the dissenting opinion praised by Attorney General Meese in his speech about jurisprudence of original intent. The principal target of that dissent was the court's endorsement of Thomas Jefferson's view that the Establishment Clause had erected, quote, a wall of separation between church and state, unquote. After identifying the source of that metaphor in the letter written by Jefferson, Rehnquist began his argument with this paragraph. It is impossible to build sound constitutional doctrine upon a mistaken understanding of constitutional history. But unfortunately, the Establishment Clause has been expressly freighted with Jefferson's misleading metaphor for nearly 40 years. Thomas Jefferson was, of course, in France at the time the constitutional amendments known as the Bill of Rights were passed by Congress and ratified by the states. His letter to the Danbury Baptist Association was a short note of courtesy, written 14 years after the amendments were passed by Congress. He would seem to any detached observer as a less than ideal source of contemporary history as to the meaning of the religion clauses of the First Amendment. After 20 pages of interesting and unquestionably accurate historical discussion, Rehnquist concluded that, quote, the framers intended the Establishment Clause to prohibit the designation of any church as a national one. The clause was also designed to stop the federal government from asserting a preference for one religious denomination or sect over others. As its history abundantly shows, however, nothing in the Establishment Clause requires government to be strictly neutral between religion and irreligion. Unquote. History not only supported Justice Rehnquist's identification of the limited purposes of the framers, but also supported an even more limited understanding of the scope of the protection afforded by the clause. The paragraph, in my opinion, for the court that replied to the intent-based argument used different language than Justice Scalia would later use in the sexual harassment case, but also endorsed the proposition that, quote, it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. These three sentences made that point. Quote, just as the right to speak and the right to refrain from speaking are complementary components of a broader concept of individual freedom of mind, so also the individual's freedom to choose his own creed is the counterpart of his right to refrain from accepting the creed established by the majority. At one time, it was thought that this right merely proscribed the preference of one Christian sect over another, but would not require equal respect for the conscience of the infidel, the atheist, or the adherent of a non-Christian faith, such as Islam or Judaism. But when the underlying principle has been examined in the crucible of litigation, the court has unambiguously concluded that the individual freedom of conscience protected by the First Amendment embraces the right to select any religious faith or none at all. Although the fact that non-Christians, such as atheists and Jews, are members of the class protected by the Establishment Clause may not have occurred to its draftsman, it is the meaning of that law, rather than the principal concerns of its draftsman, described in the Rehnquist dissent, by which we are governed. While Wallace against Jaffrey, the case cited by General Meese, and On Cale, the case involving same-sex harassment, both involve the scope of a law's protection of an individual right, the same reasoning applies to rules limiting the scope of state power. The point is perhaps best illustrated by the court's unanimous decision in Brown against the Board of Education. A study of the original intent of the framers of the 14th Amendment will not identify an interest in desegregating public schools as one of their principal concerns. Nevertheless, the Equal Protection Clause, a rule by which the states are governed, imposes a duty to govern impartially that is broad enough to prohibit racial segregation in public schools. Much of our jurisprudence interpreting that rule concerns issues unrelated to the principal concerns of its draftsmen. That is why a jurisprudence of original intent cannot provide the correct answer to novel questions of constitutional law. Questions such as whether the duty to govern impartially curtails the state's power to prohibit same-sex marriages cannot be answered by historians or by judges who limit the scope of their inquiry to a study of history. A study of what earlier students and leaders have had to say about an issue will inform the judgment that the court must make, but will not dictate the answer. Let me close by identifying another issue about the scope of the duty to govern impartially. Over 60 years ago, in a case arising in Tuskegee, Alabama, the court unambiguously condemned the practice of designing electoral districts to disadvantage racial minorities. That's the Gamillion against Lightfoot case. After I joined the court, a 5-justice majority extended that prohibition against racial gerrymandering to include cases in which the legislatures intended to enhance the political strength of the minority. I have always had difficulty with those cases because I do not understand why a law designed to make different groups more equal should violate the duty to govern impartially. I am more troubled, however, by the majority's failure to apply the rule against racial gerrymanders to political gerrymanders. Tolerating that invidious practice cannot be justified even by using a jurisprudence of original intent to search for the principal concerns of our lawmakers. If instead we correctly define the duty to govern impartially, we will put an end to a practice that neither scholars, legislators, nor judges even attempt to defend. Courts that are capable of identifying and prohibiting racial gerrymanders are certainly able to put the quietus on a more widespread and equally or perhaps more malignant evil. Thank you for your attention.
Thank you. Thank you, Justice Stevens. Is this on? Can you hear this? Hear this? Yes? Okay. So Justice Stevens has agreed to spend a few minutes answering some questions. We just asked that we have 2 people with microphones, and if you have a question to flag one of them down, and I think do we have a question? We have one starting right over there.
Yes, thank you very much, Justice Stevens. You mentioned the 14th Amendment, but I have problems these days related to the 15th Amendment and the judgment that the Supreme Court made recently on voting rights. Seems to me that the 15th Amendment, after the Civil War, pretty well should have given people, the voting rights that are being taken away right now is a subject to dispute. And I think the original intent of the 15th Amendment was not to go that way.
He's asking about your views about the 15th Amendment and how it might relate to the recent Voting Rights Act case.
Well, with respect to the Voting Rights Act, I think the Chief Justice wrote an opinion that quite plausibly explains why it may be no longer necessary to have a pre-clearance procedure. But I really think that he totally failed to explain why the court should be the institutional body making that decision when Congress reached a contrary decision after months and months of hearings and elaborate testimony, and presumably the congressmen are closer to the people who really make the important decisions than members of the court are. So I think that's a case in which you have to go behind the Chief Justice's opinion and ask why Congress did what it did and whether it was within in the scope of his appropriate authority.
Another question?
Good afternoon, Your Honor. This is a fairly open-ended question. Do you feel that today, or near the end of your tenure on the court, that the Supreme Court could be described as dysfunctional in any capacity? And if so, does that differ from any dysfunction that the court had historically at any time period, in your view?
I have to ask Sonia to help translate the questions, because one of my problems is I don't hear as well as I used to.
Sure. So the question was whether the court, as you left it, was first of all in any way dysfunctional, if it's starting to lose its ability to do the job it was there to do, and if so, if that's a change from the court as you joined it when you first came.
Well, I think anybody who has witnessed an oral argument in the last year or two certainly would not think that the participants in the argument are dysfunctional. They're very, very capable, intelligent people. So no, I don't think the court has become dysfunctional. I think it made a number of decisions that I think are incorrect, but I do think it's still a very intelligent, functioning institution.
Justice Stevens. I'm over here, but I can see most of you. Professor West, in her nice introduction, indicated you were an English major, and I think you've written some of the nicest opinions of the Supreme Court. My question to you is, of all your colleagues, who was the best or among the best writers of opinions?
Who's best writer?
Among the justices with whom I served, perhaps I'm speaking too quickly, but I always admired Potter Stewart. It's a particularly lucid and graceful writer. Just to give you an example, this is not about his writing, but about the kind of intelligence that he displayed. During the conference, the practice, when you have argued cases, the Chief Justice usually states the case and sort of summarizes the issues before he tells his colleagues how he feels about the case. And sometimes Justice Brennan supplemented what Chief Justice Berger had to say. But Potter was then the third to speak, and he almost always introduced with a paragraph or two paragraphs that was the most brilliant description of what either of his two predecessors failed to say, because he really was a brilliant lawyer and a gift for expressing himself very succinct. Just think of it, I know it when I see it. It's an awful message that comes through that. He and his separate writing in the Furman cases about being struck by lightning, cruel and unusual in the same. Potter Stewart, I think, is the one I would identify.
I had a question about the future of the jurisprudence of original intent. Is it actually on? All right. Heller was supposed to be sort of the showpiece for originalism, and yet some of its harshest critics were conservatives. J. Harvey Wilkinson likened it to Roe v. Wade. Nelson Lund called it an embarrassment for anyone who was an originalist. So I'm wondering, in light of those critiques, whether you think the court will still adhere to originalism or whether we'll see it fall out of favor again.
So he's asking about the future of originalism post-Heller, with the idea that the Heller case was meant to be sort of the preeminent moment in the sun for originalism, yet it had a lot of critics on both sides of the aisle saying that the originalism didn't work there in the case. So he's wondering what you think about if that's going to affect the future of originalism.
Well, of course, as I indicated in my talk, I think the case incorrectly interpreted the relevant intent by finding an intent to have small arms for the purpose of protecting yourself in the home. There's nothing in the history that really supports that, in my judgment. But I think there are fans of the original intent approach to jurisprudence, like the judge on the Fourth Circuit, his name escapes me, have very severely criticized the historical analysis in the case. So I think that I don't think it's going to put an end to the original intent scholarship, but but I think it's an example of a case that was incorrectly decided even under that approach.
We probably have time for one or two more questions, if there's any.
So I appreciate that you mentioned some of the problems perhaps with original intent and how it relates to gay rights under the Equal Protection Clause. I think some of the issues that you were touching on, particularly with bad history, creeped into some of the dissenting opinions in the Windsor decision. Do you have any thoughts about some of the ways that the dissenters in Windsor use history and tradition, and maybe kind of some thoughts on ways that the majority opinion in Windsor could have been improved and addressed those concerns by the dissenters?
Okay, so he's asking about the Windsor decision, the DOMA decision, and he said there was a great use of history by the dissenters in that case about the history of marriage and what that meant, and so he's curious what your thoughts were about the use of history in that case.
Well, I never objected the use of history. In fact, I used a lot of history in the Heller dissent. I think it's a perfectly proper subject to examine, to learn more about the issue and different attitudes toward an important issue like that. But I think it is not a correct standard by which to make the final decision in case after case. I mean, just going back to the gun cases for just a moment, you look at the text of the Second Amendment that talks about the importance of a well-regulated militia, and you then think about the McDonald case relating to the right of Chicago to enact its own gun laws. It's ironic that the last word on whether a state's regulation of firearms that's so important should be placed in the hands of federal judges rather than state legislatures. It just isn't quite right. But I certainly do not criticize anyone for studying the history about an issue to learn more about it. I believe that's entirely correct, but I think it's quite wrong to think that the history will always provide an answer, particularly when you're defining the outer limits of an important constitutional principle.
Okay, I think we have time for one final question. Oh, okay.
It's been proposed to get some of the politics out of Supreme Court appointments, that each appointee be given a single 18-year term, staggered every 2 years, so a president would, absent death, appoint a justice every 2 years. Wondered what you think of this idea, realizing that in your particular case, it would have been a bad idea.
Okay, so he's asking about a proposal to have basically term limits on Supreme Court justices of 18 years with an appointment every 2 years so that presidents would get an appointment, and what you would think about that.
Well, there's certainly not, it's not a frivolous suggestion by any means. I'm sure there's a lot of merit to it, but I'm happy they didn't have such a statute or such a rule in effect during my term, and I do think in the long run, allowing judges to continue to serve while they're capable of doing so is in the country's best interest, and that the problems will solve themselves in due course. I think for the most part, there have been 2 or 3 examples where the judges stayed on longer than they should have, but for the most part, the judges are able to let one another know when it's time to retire. Of course, I was deserted by my friend Justice Souter, as you know, but that's...
That Justice Souter was supposed to be the one to tell you, and then he leaves first. That's not fair. Well, I'm in the position, unfortunately, to tell us when it's time to go, and it is time to go now, but I want to thank you so much for making the trip to Athens. It means so much to us. Everyone is very...